This is part 4 of contracts, beginning with defenses to formation, beginning with mistake. Mistake is a fact that is not in accord, or a statement that is not in accord with existing facts. This goes to a basic assumption on which the contract was made that materially affects performance. You have a bilateral and a unilateral mistake. A unilateral mistake is generally enforceable. An exception is where the mistaken party may void the contract if they did not bear the risk of the mistake, and it's unconscionable, or the non-mistaken party caused the mistake or failed to disclose the mistake when they had reason to believe the other party was mistaken. So if the mistaken party did not bear the risk, it must also either be unconscionable, or the non-mistaken party caused or failed to disclose the mistake when they had reason to believe the other party did not know of the mistake. And you have the defense of material misunderstanding, where both parties believe they are agreeing to the same terms, but they are actually not. Here there's no contract, there's no mutual assent. In the context of material misunderstanding, where one party is mistaken as to the basic facts or terms, here they have formed a contract based on the terms as understood by the unknowing party. So where one party has a misunderstanding and the other knows and or should know of the misunderstanding, then the contract is formed, but that contract is formed on the terms as understood by the unknowing party. Prevents the other party from being taken advantage of. Defense of formation, fraudulent misrepresentation. A misrepresentation generally is an assertion contrary to existing facts. And this assertion may be innocent, negligent, or fraudulent. And it is fraudulent, or a fraudulent misrepresentation, where it is made knowingly, without confidence in the assertion, and the person making the assertion knows no basis for the assertion. And the defense to formation of nondisclosure. Nondisclosure of a known fact is tantamount to an assertion that the fact does not exist if the non-disclosing party knows the disclosure would prevent the prior assertion from being a misrepresentation and or fraudulent, or correct a mistake of the other party as to a basic assumption and failure to correct amounts to bad faith, or correct a mistake as to the contents and or effect of a writing evidencing the agreement, or the other party is entitled to know the fact based on a confidential fiduciary relationship. Again, non-disclosure of a known fact is tantamount to assertion that the fact does not exist if the non-disclosing party knows that the disclosure would prevent those conditions. Defense to formation, fraud in the execution. You have fraudulent misrepresentation. This is fraud in the execution. It's a fraudulent misrepresentation that prevents a party from knowing the characters and or essential terms of the contract. Here the contract is void. There's no contract. Now there's an exception, and this exception is where the reasonable diligence would have revealed true terms of the contract. Then the person induced into the contract may have, or fraudulently brought into the contract, may be held to the contract. You have a duty to do some due diligence. You have fraud in the inducement, the defense to formation. This is a fraudulent misrepresentation that induces another to enter into the contract. Here it is voidable by the induced party. But the induced party must have justifiably relied on the misrepresentation when entering the contract. If the misrepresentation is extravagant or extreme, then they can't justifiably rely on that. Looking at the defense to formation, unfair persuasion under undue influence. This is where you assume one party will not act against your interests. You trust somebody. Or one party is dominant over the other, where the other is dependent, where you rely on the experience or expertise of the other party into entering the contract, or you have diminished mental capacity. Here the contract is void in all cases, so there is no contract. No contract is formed. Defense formation of duress. This is an improper threat that deprives a party of meaningful choice. It can be a threat of crime or tort or criminal charges. Civil prosecution. A threat of civil prosecution is generally okay, but not if made in bad faith. Duress can also be the deprivation of a meaningful choice. This is where you have a civil action with the threat of property seizure. You're trying to negotiate a settlement. You threaten them with property seizure. This would prevent the party from fulfilling their other obligations. They really therefore have no meaningful choice but to settle under your terms. Here that contract is void. The defense to formation and infancy. This is the capacity to contract. An infant is any party under the age of 18. Here they have no capacity to contract. That's a general rule. The contract here is voidable by the infant only. The other party cannot void the contract, or it's not voidable by the other party. The infant may disaffirm. Here the contract is then void, but this contract must be disaffirmed by the infant before reaching majority, the age of 18, or a reasonable time thereafter. Otherwise, the contract is considered ratified. If the infant disaffirms the contract, the infant can avoid any liability under the contract, but the infant must pay a reasonable value of any necessities furnished to them under the contract. The second restatement of torts states that infants generally must restore benefits received under the contract if possible, and I believe that goes to the statement I just made previously of necessity. Look at defense to formation and mental illness. Again, this goes to capacity to contract. If you are adjudicated incompetent, the contract is void. So there's no contract. If there's no adjudication, the contract is voidable by the incompetent, but may be disaffirmed if they're unable to understand the nature and or consequences of the contract or act in a reasonable manner with regard to the contract, and the other party has reason to know this. Now, when you're not adjudicated incompetent, if a contract is made while you're fully competent, you have a moment of lucidity, then the contract is fully enforceable. Intoxication, the defense to formation. Again, this goes to capacity. Here it is voidable by the intoxicated person if they are unable to understand the nature or consequences of the contract and the other party has reason to know of the intoxication. You can consider the circumstances under which the contract was made or knowing the history of this person. The intoxicated person where the contract is voidable, they must act promptly to disaffirm and return any value received under the contract. Defenses to contract or defenses to enforcement. Prior we were talking about defenses to contract formation. This is defenses to enforcement of the contract. You have to have two bases for defenses to enforcement. The basis for defense must challenge either the nature of the contract, so it's illegal, or the manner in which the contract was arrived at. Look at defensive to enforcement illegality, where consideration and or performance requested is illegal, such as I'll give you a pound of coke if you paint my fence. Here this contract is unenforceable. Where the contract contemplates illegal conduct, it is void. Now there's no restitution or remedy for partial performance of an illegal contract unless the party is ignorant of illegality. Now you may recover if the other party knew. So you're ignorant of the illegality. To recover for partial performance, the other party must have known of the illegality. Defenses to enforcement and unconscionability. This is where the contract is so unfair that no reasonable person would have agreed to it. It must be as the conditions as at the time that it was agreed to. Now you may apply that this unconscionability may apply to boilerplate contract language and or complex or hidden provisions in the contract. And that completes part 4 of contracts.